Alright, guys, it's been a bit of a time, but let's just quickly review because we'll tell you what's going to happen from here on out. I haven't gone in the sequence of the CBC. I told you that at the beginning. It's difficult to follow it through more strictly according to the CBC. We've tried to follow the trajectory of a suit, but there again, there's been a bit of a deviation, and that was for a reason. We went into the written statement because we were doing pleadings. We jumped from that to interim applications because logically when you're in court, working with counsel, your firm, the first thing that you do is file the claim and file an I-8, and you'll be in court for an interim application. Please remember this, that 99.9% of the time, there will be no written statement when you are in court arguing the first interim application that you file along with the suit. There is always a possibility, of course, that there are interim applications much later in the life of the suit, even after the written statement is filed. Those may be of the same kind, but we have not got there yet. Park the written statement for a moment, we'll be returning to it. Now, when we did interim applications, we looked at injunctions, we looked at arrest and attachment before judgment, we looked at the appointment of receivers, and we considered those two other types of orders and whatever injunctions and injunctions. Now, I'm going to go slow from this point, because this is really the heart of it. This is where it becomes very difficult. So let me just give you a bit of a roadmap about what's happening. There are, now from this point on, certain crucial concepts that you have to understand early because they lie at the heart of civil law. There's also a whole bunch of peripheral procedural things, such as the issuance of a summons, getting parties to court before the trial, summoning attendance to court, what happens if a party shows. We'll come to that, I'll guide you through that. Most of that is self-evident and you can read it on your own. We are not going to be able to have the time to get into that in excruciating detail. And frankly, beyond a point, it's really boring. But it's stuff that you are unlikely to be asked on. And in practical terms, it almost never hits you in the face, and let me tell you why. We'll discuss this when we come to those parts, but when you file the claim and you have a summons, bit of summons being served, the written statement comes in, there's the oddball case where you got to refer to this procedure, part of the procedure, what happens if the party doesn't show up, what happens if the summons isn't served. We'll get into that. I'm still on now the interim applications. And I assume that one of you has argued it against someone else. And inevitably, whether it's an interim or an interim order which goes so small, one party or one side has won and the other side has lost. There are cases where both sides lose. Everybody's are happy. There's almost never a case where both sides are happy. The next logical step that happens from this is that your senior tells you file an appeal. And this is when you get absolutely clean bold. Now, if you want to be, well, in today's terminology, Joe Root, chasing a record, you better understand what's being bowled at you. And for this, you have to understand the different types of appeals. Now, don't confuse this with other more complicated stuff like review and revision, which we will get to later. But there are appeals and there are appeals. And not all appeals are the same. To understand what an appeal is, you have to understand what you are appealing from. critical. An appeal from a decree is different from an appeal from an order. So let's understand these concepts. Now, this is where it gets very rough. 3 words in the definitions of the CPC: judgment, order, and decree. And you will be hit with this in almost every single solicitor's exam on CPC. I mean, guaranteed short questions somewhere down the line. And it's for a reason. Because this is one of those critical concepts in the Civil Procedure Code, and it exists like this for a reason. Now let's just look at this sequentially first. We'll have to read this 2 or 3 times. But let's look at it sequentially because it's arranged alphabetically. So now, and then I'll reverse the sequence for you. Look at the definition of decree in section 2.2 of the code. Does everybody have a copy of the CPC, or can you share, please? That India code has soft copies which are very up to date, so you should download them. Is there you have a copy of the CPC? No, you'll have to follow it because you won't be able to see. Okay, so I'm going to read this slowly, and there are key words here that you have to follow. Decree means, now mark this next word, formal expression. So just tick the word formal. Expression of what? An adjudication, which so far as regards the court expressing it, so it tells you who is doing this, conclusively determines the rights, crucial, conclusively determines the rights of the parties with regard to all or any, now there's a reason why it says all or any, of the matters in controversy in the suit, and it may be either preliminary or final. Just stop. There's more, but just stop. Let me break this up. One, we are talking about the court, which is hearing. 2, we're talking about the parties who are before. This is important. It's a triangulation. Court, party, party. Parties are in contestation. Issues have been drawn. There are points of controversy. The court is called upon to decide, and the court decides or determines the rights of the parties. That means either in favor of the plaintiff or in favor of the defense. In regard to, now, any of the matters in controversy means the issues, which is a separate section of the CPC. And the first words tell you how it is done. It's a formal expression of an adjudication. Adjudication is the judging process. But a decree is not the judgment. The decree is, this is why it's crucial. It's the formal expression of an adjudication. I'll give you an example and then we'll take more. There is a suit for recovery of money. Issues are framed. There is a discussion on the evidence. There are reasons given by the judge. And at the end, the judge says, decree in favor of the plaintiff, there shall be decree in favor of the plaintiff in the amount of 5.5 crores with interest at 18% per annum from the date of the decree till payment or realization. This is the formal adjudication. This is the formal adjudication. It has concluded. exclusively determine the rights of the parties, the plaintiff is entitled to recover from the defendant, and the defendant is required to pay this amount. Now, this decree can be about anything. It can mean, since you're so fond of it, defamation suits. It can be in a damages claim, an action in tort. It can be in a specific performance suit. It can be partition, it can be administration. Now, why do you imagine we've got this concept of preliminary or final? What, according to you, is likely to be a preliminary?
Sir, preliminary decree is when the court determines something and there is some other part which requires to be determined.
What an example of that?
Sir, as you said, a partition suit.
Correct.
First,
Partition suit, a preliminary decree will typically do what?
determine the rights that the plaintiff has.
No. Partly correct. It will determine shares in the property to be partitioned. This will happen in an administration suit. There can be a preliminary decree in a mortgage act also. There can be preliminary decree. And the final decree is the one in a partition suit that directs the division of the property or the sale of the property or makes other arrangements. Alright, so clear so far. Now on this, from this, please stop me if you have the slightest doubt, because we've got to get this crystal clear before we go ahead. Okay. Now let me read the next part. It shall be deemed to include the rejection of a claim, which we see, and the determination of any question within the meaning of section 144, forget that, but shall not include. Now, you remember, this is return, not return of claim, rejection of claims. 711, the rejection of the claim, want of a cause of action. The suit is dead, therefore that becomes a decree. Any act, but shall not include, a decree shall not include any adjudication from which an appeal lies as an appeal from an order or an order for dismissal or default. Now you have to understand this graphically, because there are exceptions and there are inclusions when you look at the decree. So we've seen the ingredients, but it does not include, what? Anything from which an appeal lies as an appeal from order. This box excludes appeal from order. There is one exclusion built into the definition of decree. So again, we are going alphabetically. Now look at judgment. Judgment means the statement given by the judge on the grounds of a decree or order. What does this mean? It says decree or order. We've seen decree. Now judgment logically says grounds given by the judge for a decree or order. What do you think this means? In plain English, translate. Reasoning. What does this mean, grounds? It basically says, why am I passing this order, or why am I issuing this decree? These are my reasons, this is my analysis. That's the judgment. So there is a component. Now come to the order. An order means a formal expression of any decision. We did not say adjudication. Of a civil court, which is not a decree. If by this time you are not thoroughly confused, so now sequentially
hierarchically, we've got decree. An order is defined in the negative as everything that is not a decree. And the judgment is the reasons for either the order or the decree. So the critical thing to understand here is the decree, because anything that's not a decree is an order. It's the default basket. If it's not a decree, it's an order. There is no third possibility. There is no third possibility. In civil law, in a civil suit, and remember, we're not talking about the writ court, okay? Other things happen in a writ court. This is a civil suit, a civil court. There is either a decree or an order, and the judgment is the reason. Now, conceptually, please understand why this is important. Can you stay a judgment? This is the googly. This is the, in cricketing, this is now the yorker. Can you stay a judgment? Why not?
It's the reasoning.
Correct. Now you will very often find appellate courts, including the Supreme Court, saying judgment is stayed, judgment can't be stayed. The order which directs something to be done, or the order which dismisses, the order can be stayed, or the decree or its execution can be stayed. Judgments can't be stayed because there is nothing to stay. It's just the reasoning of the judge. Don't make this confusion. When you say, when you are pleading in an appeal, the stay of the judgment, no. Stay of the decree, stay of the execution, stay of the order, yes. Not this. Okay. Now I want you to please look with this at one step back, where we were when we were doing interim applications. And let's consider a number of possibilities there where you sought an injunction, you sought a receiver, attachment before judgment, etc. When the interim application is disposed of, what have you got in your hands? Is it a decree? Is it an order? Or is it a judgment? Or is it bits and bobs of all of this? It's an order. Why? Go back to the definition. No, don't guess. Go back to the definition. It's an order. No, I want you to be careful. Just wait. You're saying it's an order, not a decree. I'm asking you why you're saying that.
Because it has conclusively determined all the.
That's the point. It's an interim order. It has not conclusively determined. The word is adjudicate. The word is conclusively. The word is rights of the parties. Conclusive adjudication of the rights of the parties means there's nothing more left to be decided. End of the road. Clear? Interim orders, and we saw interim and interlocutory, are putting people in a holding pattern in the best possible way. Because it is just and necessary, because it is balance of convenience, for all these reasons. Therefore, it is not a conclusive determination of the rights of the parties. Okay, complication, because we live in a world of complications. Suppose there is, alright, can an order on an IA be a judgment?
Yes.
Can it have a judgment? That's the reasoning. Can the judgment in an IA be binding? Careful with your answer.
Yes.
No. Can the judgment in an IA serve as a binding precedent for that court of the later court? Think.
It can't, because it does not conclusively it has determined the rights of the parties. Therefore, It's
The judgment is a combination of a prima facie assessment of facts. So to the extent that it is a prima facie assessment of facts, it is not binding. But the reasons in the judgment, to the extent that they pronounce or settle the law, can that not be binding? Example, the rights of tenants in a matter of reconstruction of a C1 category dilapidated building. Two distinct areas here. What are the facts that are peculiar to this particular building and these particular tenants? Second part, what is the law generally regarding the rights of landlords, the rights of tenants and reconstruction under the Maharashtra Regional Town Planning Act and under the BMC Act? Why should the judgment which states the law or sets out the law not be a binding precedent merely because it's at an interim stage? Common mistake. Very common mistake. A judgment on an IA can be the final word as a binding precedent. Remember the concept of stare decisis. Because it determines or it lays down the law merely because it's at an interim stage. And I'll tell you what the logic is to this. Does not mean that the judgment on law is not binding. Because if you were to say the other way, that is a prima facie view. It's a prima facie view on facts. But it is the final view on law. Although it hasn't determined the rights of the parties, evidence is yet to follow. If the law is laid down in an interim application, in an IA, how is any amount of evidence going to change that position in law? Why should the final hearing change it? That won't change. Applying that law to other facts that come in after evidence may change the result of the suit, but the law will not change. So to that extent, so be careful about this. Now this gives us a very interesting split, because we've got order now, which is not a decree, and somewhere in between we've got the judgment, right? Now, remember this, what we've just discussed is this great split that we see here between facts and law. This in an IA will take a prima facie view, which will be an order. These facts, when there is a formal adjudication and a final conclusive determination, will lead to a decree. Clear with me so far? The judgment that we are talking about here will be used to support either of these or both of them together. Understood? Now, next steps. One of you has succeeded in the IA. One of you has lost. There's an appeal that's coming. So now let's go to the index of the CPC, because there are two portions that I want you to have a look at. Then we'll go through them a little more carefully. But I just want you to see the chapter headings, and because this will give you an idea of the lay of the land. Okay. Part 7, just above section 96. Section 96. This phrase is important. Appeals from original decrees. Read the next caption. Appeals from appellate decrees. Appeals from orders. General provisions relating to appeals and appeals to the Supreme Court. Right? Now, appeals from original decrees means what? Okay, sorry, just step back one step. Why do we have in our system based on Roman law, very old Roman law, provisions for appeals at all? What's the logic to having a provision for appeal? Nothing here is without logic. What's the logic? Apart from the logic of keeping lawyers gainfully occupied and making sure they have a profitable existence, why do we have appeals?
In case the court of first instance has ordered the judgment.
Okay, warm but not hot enough.
System of corrections.
System of correction. The general principle is that every person must have at least one chance to appeal, because judges are human and there's a possibility of error. That's the logic to it. At least one appeal. Now, when you look at this sequencing, you will see in the first two that there is something called an appeal from an original decree. What does this mean? Appeal from, this is appeal from an original decree. And this word is now important here. And what does this mean? What is appellate? Sorry, both are decrees, huh? I'm sorry, this is also a decree. And these words you will bear in mind. What's an original?
We passed when the court is using its original jurisdiction. So an appeal against
Explain.
the appeal of a court
Explain. Which is the court of original jurisdiction?
Court of first instance.
Court of first instance. Court where you file the suit. The court where you file the suit. Don't confuse this with the original side of the Bombay High Court. It just means that the Bombay High Court is the court of first instance. This is the court of institution. What is an appellate decree?
Sir, appeal from the appeal from
So
the-
this decree has gone once into appeal already and has resulted in a second decree which may confirm, modify or reverse. Appellate decree. Now see what's happening. This, an appeal from an original decree, is a first appeal. On the appellate side in practice, these will be numbered as FA number something or the other. Always. An appeal from an appellate decree is a second. Now see, this is, as we go through this, you will feel like sort of curtains are being raised because you're now understanding what these terms actually mean. Once you understand that this is a decree, the first appeal, and in, by the way, on the original side, the word is never used as first, it's only called an appeal, correct? There's a very important distinction about what happens here and what happens here. A first appeal is said to be an appeal on facts and law. What does that mean?
It has the power to reappreciate facts.
Reappreciate the evidence.
Yes.
Reappreciate. Now, everybody, because we got so used to doing the other kind of appeal, which we'll discuss in a minute, everyone has forgotten how first appeals are done. Let me tell you how they're done. Because this is how you will argue it. This is how you will hopefully one day judge it. You do not, in a first appeal, begin by reading the judgment of the lower court at all. Because it's an appeal on facts and law, it is as if you're re-arguing the whole thing. The difference being the evidence is already there. You would take the judge through the plaint. This is the classical first appeal. The plaint and the written statement. And I'm talking, for example, that there is a first appeal coming up from Khopoli or somewhere in Raigad district. Remember the chart that we initially seen about jurisdiction, and I will assume that the first appeal has come to the High Court. Then you will tell the appeal court, the first appellate court, not what issues were framed by the trial court, but the points that arise for consideration. You will then take the first appellate court through the evidence on those points and the law, and it is then and only then that you will look at the original decree and its supporting judgment, so that the first appellate court will decide whether it is to be upheld, modified, partly reversed, fully reversed. The judgment, the original judgment, comes in at the tail end, at the far end of your presentation of a first appeal. Always. No shortcuts. Because a first appeal is an appeal as a matter of right, there is no question of opposing admission of a first appeal. People often get up and say, I want to file an affidavit to oppose admission. It's not a limitation. A first appeal is an appeal as of right. Every person has a right to appeal. The first appeal has to be admitted. The maximum you can do is ask for a quick date saying that the evidence is small or the issues are narrow or whatever it is that you want to do. You cannot oppose admission of a first appeal. Now, in a first appeal, you may have an IA. Just layering on the complications. We're not there yet. So don't try and say that you're going to file an affidavit, you'll be laughed at, to oppose admission of a first appeal. It has to be admitted. If there is an IA for interim relief, ask for time to deal with the IA for interim relief in the appeal. Especially if they're seeking a stay on execution or whatever it is that they're seeking a stay on, separate matter altogether. There are provisions for stay, there are provisions for security, which we'll be discussing shortly. But don't oppose this, right? First appeal on facts and on law as a matter of right. As a matter of right. Complication. When there is a preliminary decree, can you file a first appeal against the preliminary decree after the final decree?
No.
Correct answer. Correct answer. Remember this. Both are decrees. They are preliminary and they are final. Each will take its own first appeal. In the simplest case, a partition suit, for example, declaring that party A has a 50% share in the property and parties B and C have 25-55. And this is being opposed, saying that no, it's 1/3, 1/3, 1/3. A decree must be filed, an appeal must be filed against the preliminary decree, because otherwise that decree will attain finality when you come to the final decree stage. Bear this in mind. Second appeal follows the decision in a first appeal, which again will have a judgment and will have a first appellate decree. Not order, first appellate decree. It will be an adjudication by a court, and it will conclusively determine the rights of the parties in regard to the issues in the suit. So it's a first appellate decree. Second appellate decree, you can't have indefinite bites of the cherry, is far more restricted. This will be on a substantial question of law. Why do we need this second appellate decree provision? It's a fail-safe. That if the two courts below have wrongly applied the law, not the facts, no reappreciation of facts in the second appeal, required reappreciation of facts in a first appeal, huge difference. And if you were to make a tabulation, differences between first and second appeal, you will see these differences. And both of these are to be distinguished from the position where we are, which is an appeal from an order. Now, one of you, because we've been through this, have to tell me why an appeal from an order is different from a first appeal and is different from a second appeal. What's happening?
So first appeal and second appeal are actually appeals from a decree, and those are appeal from orders.
Therefore what?
Because an order is not a formal adjudication.
It may be a formal adjudication, but it's not conclusive.
Not conclusive.
Yes.
A decree is inherently appealable unless otherwise specified, whereas an order is not inherently appealable.
Also correct. Also correct. Because the order is defined negatively as a non-decree, for want of a better expression. An order is a non-decree. There may be a judgment supporting the order, just as there's a judgment supporting the decree. But the order is everything that's not a decree. It's the default thing. This order is never done on an assessment of the evidence at trial. It's not a final adjudication. It's not a conclusive determination of the rights of the parties. It is that prima facie thing. Right? Now, you will therefore be filing what is called an AO. An AO is not an appeal as of right. An AO is discretionary because the IA was discretionary. The IA is determined by certain factors such as prima facie, balance of convenience, and so on and so on. Let me assume that you are in the appeals court, either in a DB, hearing a original side AO, appeal from an order on an IA, or hearing an appeal coming up from the city court. What are you going to look at as a judge? I'm reversing this because then we'll come to what you'll have to do as a lawyer. What are you going to look at as a judge when you're presented with an appeal from an order in an interim application? Are you going to look at the plaint and the written statement first, and then for what purpose? There are no issues framed yet. There may not even be a written statement. You are going to look at the IA. You are going to look at the affidavits. But first, and this is the entire mirror image and the reversal, you are going to look at the impugned order. What are you checking the impugned order for? Sorry? Whether the prima facie and the three ingredients were met. What else? Prejudice is one of those. What else? Well, here's the judgment that you have to look at, which is the classic judgment on this matter, which is Wander versus Antox. And you find this before the next one. And you also look at Shah Babulal Khimji. You find both of these, we'll discuss them on slightly different angles. Fundamentally, this is the law by the Supreme Court, is that an appellate court should not interfere with an interim or an ad interim order unless it is demonstrated that it is so perverse that it could never have been passed on the facts and circumstances of that case. I'm putting it very broadly. You'll find the wording in paragraph 14 of Wander versus Antox. Find this. That's your guiding principle. So when you get into filing an AO, you have to dislodge it by saying the successful party did not have a prima facie case, failed the test of balance of convenience and irretrievable injury, and the order is such that it is not a reasonable order, one that could have been passed given the facts and circumstances of the case. That is precisely how you will argue it. Very different structurally and conceptually from arguing a first appeal. Look, I've taken you through these as concepts rather than dive into the sections, because when you understand how this structure is, the sections will begin to make sense. Otherwise, it will just not make sense. Okay. We haven't got to appeals to the Supreme Court because that's a separate provision. I'm leaving that aside. We'll park that for the moment. Any questions on this so far? Yes.
So you mentioned that there's something called as the IA is discretionary. Therefore,
all IAs are discretionary.
Therefore, the appeal from the IA will also be discretionary.
That's correct. Which you may not. An AO is sometimes admitted, but if you are opposing, you are the successful party in the court below, you are entitled to tell the judge that I want to be heard before this AO is admitted or before any order is passed, which you are not entitled to do in a first appeal. The first appeal is one as of right. It's a statutory right. That's the difference. Clear? So you can be heard at the hearing of the AO. Generally, a court will say on the AO, is the other side served, issue notice, and so on. Yes?
The conditions apply to the second appeal also? That I can't oppose a second appeal?
Oh, you can, sorry, you're right. Good question. The second appeal, in fact, can be opposed on the ground that no substantial question of law arises. No substantial. But generally, in a second appeal, the other party will sit, if it knows what it's doing and is sensible, will not open its mouth. You will sit there with a smug expression on your face because that second appellant has an uphill task. You've got 75 years of law. He has to find some little crevice to be able to say that this question of law has remained undecided. You have to sit on the other side and laugh. 9 times out of 10 in a second appeal. Now, unfortunately, what's happened is that there are tons and tons of second appeals that are pending admission. The admitted ones are very, very few. And often the pending ones are on a question of civil procedure, evidence, some intricate aspect of civil procedure. Could this be done? Could that be done? And so on. Transfer of Property Act. Those are questions that will typically arise in a second appeal. Generally, as a strategy, in a second appeal, you shouldn't open your mouth because it will probably self-destruct in a Mission Impossible kind of style on its own at some point without your having to do anything. If it gets admitted, you argue it at some point whenever it comes up. It's purely on law, so you'll have to dig and research. That's about it. Any other questions on this before we move further? Yes?
How do you classify the preliminary?
I can't hear you very clearly.
How do you classify the preliminary degree and final degree, sir?
There are types, there are various kinds of suits in which there will be a preliminary decree and final decree. A partition suit is one, for example, where the shares of the parties are ascertained at an initial stage. I'll tell you how this works. Take 2 examples. Administration suit, where we are dealing with the estate of a very rich person who died. And the question is that his estate has to be divided. Somebody has to administer this estate. Every one of the heirs in the family tree will have a defined share, governed by the law that governs their succession. Mohammedans are different from Hindus and so on and so forth. Hindu male, Hindu female, where the heirs are in the hierarchy and so on and so forth. Once you have that, you know that the testator had, or not the testator, the deceased person had a 100% share in the property, in this property. And each heir has a defined percentage because of coming down the family tree. Complications arise when the deceased person himself had not a 100% share, but a 25% share with his brothers. Then his 25% share gets divided further asset-wise. A preliminary decree typically will determine the shares of the various heirs and legal representatives in that asset or in that asset class, as a percentage. Person has 0.25% interest or 1.25% or 0.375, or sometimes expressed in fractions. This becomes important because very often in administration and partition suits, the descent down the tree is not clean from the top, in the sense that the person who held the asset often held only a fractional interest in the property along with others. Now it's possible that 3 or 4 brothers or cousins owned a large tract of land. It's not HUF, but owned a large tract of land. And one of them dies. One of them dies without leaving lineal descendants. The other one has lineal descendants. So if 2 of the 3 die, this gets complicated because the one who died without lineal descendants, the brothers and their branches would have a share in the deceased childless brother's estate. The brother who died leaving lineal descendants, his lineal descendants will have this plus that. So you have to get this, and these shares are analyzed, decided, argued for the purpose of a preliminary decree, but those shares are decided and in the preliminary decree, if not challenged, become final. Then how that property is to be sold, how it is to be divided, how the sale proceeds are to be done, are matters that will come in the final decree, but the distribution will be according to the shares adjudicated conclusively in the preliminary decree. Incidentally, this calculation can get very, very, very contentious depending on various other unknown factors such as adoptions. For example, in Hindus, when there is an adoption, then the question of the validity of the adoption is questioned. But if the adoption is accepted, the whole percentage shareholding of the whole family tree changes. In Mohammedan law, it changes significantly depending on which school of Mohammedan law governs you. Hanafi law may say this, and Khoja law may say something else. And these are variants that you have to be careful about when you're analyzing this, and there is personal law of succession being applied. Partition suits in commercial properties may be relatively easier because shares are determined by a partition deed, by a partnership deed, partnership, not partition. But partition could be of various kinds. Family held property, ancestral property. Again, shares have to be decided like this. This is what would happen in a preliminary decree. All right. Anything else? Yes.
Can there lie an appeal from an order for dismissal for default in a second appeal?
Wow.
Because then...
No. You'll have to file an IA for restoration. There won't be an appeal, but there will be an IA for restoration of the second appeal. Okay, now, sorry, yes?
One point, your Lordship mentioned that judgment in an interim application is not binding as regards the facts are concerned.
It can never be.
Correct. And as regards the laws...
It could be.
It could be. So as regards appeal from order, is
Same
that...
thing.
Same thing. So
Same thing.
It can
An appeal from an order, this has happened before. And actually that's a fairly smart approach to it. So just listen to this. Let's assume there's an IA which seeks attachment before judgment. Or let's complicate this and seeks a Mareva injunction of the kind that we discussed. In an AO from this, the law of Mareva injunctions in England, where it originated, perhaps in America where there is a parallel provision, and in India is discussed in appeal in the AO. That judgment on law can serve as binding precedent, but it does not conclusively determine the rights of the parties at the final stage. That depends on the evidence. So the law can be stated conclusively at any time, but as a statement of law. As a statement of law. It's not necessary. See, many people often say this, that there is a very lengthy judgment. You have cited tons and tons of law at the IA stage. Why are you doing this? You are inviting a ruling, you are inviting a judgment, saying decide this as a question of law. Decide this question of law. You are not doing it because it's just to fill time. And if judges were to decide interim applications without any regard to the state of the law or an analysis of the law, this would be some sort of quasi justice. I feel like it. What you feel like doesn't matter. It's what the law lets you do. The common mistake is to say that judgment that pronounces a law and takes a prima facie view of facts is only at the interim stage, therefore it is not binding. On law it is binding. It's not going to change between the IA and the decree because some evidence has come. That law will be applied to a prima facie view that law will be applied to a final view when the evidence is in. That may change the end result of the suit. Possible. That's possible. Or in specific performance. After the amendment, what is the law on specific performance and how has it changed? This may be a judgment that is rendered even at an interim stage to decide whether I can grant or not grant interim relief. That's entirely possible. That judgment will hold. The judgment on law will hold. On facts, when you apply it, may have a different result.
Then is it right to say, just like first appeal from order is also an appeal on facts and law?
No, it's not. No, it's not. An appeal on facts and law in a first appeal is a reappreciation of everything. Of everything. An appeal from an order is not an appeal on facts and law because all the facts are not in. It's on a prima facie assessment of the facts. Should interim relief have been granted or not? And should it have been granted like this? Would a lesser relief be possible? Has this caused prejudice? Is there a prima facie case? In a first appeal, there is no question of a prima facie case. It's the suit. There's no prima facie thing about it. There's nothing prima facie about it. In fact, don't use the word prima facie in the first appeal, you'll be laughed at. Ever. But don't forget to use it in an AO. It's your jump off point there. Remember, make that distinction clear. Yes?
So going back to the definition of decree, it excludes an adjudication from which an appeal lies on appeal from order and any order which is for dismissal or default.
Yeah.
In A, why couldn't they just have said any order? It excludes any order. Why do they have to say adjudication from appeal?
That's what we're going to see. We're going to see this. Because not all orders are appealable. That's the detail. That's the sting in the tail. That's what we're coming to. All decrees are appealable. But all orders are not appealable. That's the next layer of complication that we're coming to just now. I wanted to give you a structure just now of understanding how this a first appeal, second appeal and an AO is. Now we'll get into the details of this. Okay? But that's a very good question. Hang on to that because as we see, there are some orders from which no appeal lies even as an appeal from an order. None. So don't even try that. Okay. Now, let's move ahead. So, if we look at now section 96, of the CPC, there are just a couple of things that I want to point out to you. Save as otherwise expressly provided in the body of this code or in any other law. Now these words you have to understand because this is appeal from original decree. An appeal shall lie from every decree. It's an appeal as of right. That's why I said this. Shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals. But there is no appeal from a consent decree, that is subclause 3. An appeal does lie from an ex parte decree because you will see that one of the options is to file an application for setting aside an ex parte decree to that court or an appeal lies. No appeal shall lie except on a question of law. This is for the small causes court. Just ignore subclause 4 for the time being. Okay, that's because of the small causes court jurisdiction. Alright, now, since the question was about a preliminary decree, please have a look at 97 and see what happens. You answered this yourself, but it's there in the code. Where any party aggrieved by a preliminary decree does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal from the final decree. Logic to this, which we saw. Okay? You skip 98. Come to 100. I am giving you an idea of how this thing operates in practice. Now, save as otherwise expressly provided in the body of this code or by any other law, for the time in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court. Now, if it had stopped there, things were different. If the High Court is satisfied that the case involves a substantial question of law. Now again here, one slight tweak. Every first appeal does not come to the High Court directly. Every second appeal comes to the High Court. In our civil hierarchy, there will be a court of original jurisdiction, civil judge junior division, and the first appeal will lie within that court. The second appeal will come to the High Court always, but qualified, involves a substantial question of law. And look at subclause 3, because this people forget. In the memorandum of appeal, you must precisely state the substantial question of law. And then if the court is satisfied, the court must formulate the question. It may not be exactly as the appellant puts it. So there's a great deal of argumentation that happens at the time of admission of the second appeal on both sides about whether there is in fact such a substantial question of law. My experience has been both here and in Goa that the bar is usually fair about this. A lawyer will often say, I quite see the problem. Would your lordship give me 2 days time to consider the position and try and formulate the question? To which we usually say take a week, but formulate it. And he comes back, or she comes back the next week and says, really I can't. But please don't record consent. So that's what you do, saying no substantial question of law arises and dispose it off there and then. It's very, very difficult. This is the real forensic skill, is formulating a substantial question of law here. It's not an easy job. It's not an easy job. And it's not even very fashionable. And it's certainly not very seductive, because it's just a lot of work for very little remuneration. When most people are jolling along doing IAs, AOs and SLPs, which is altogether more energetic and hugely more remunerative. So you're not going to encounter a second appeal, but if you do, remember this. And remember it for your exams in any case. Now 100A is important, just one. 100A is important for one reason, that it puts a quietus to incessant appealing. Okay? I'm skipping the rest of sections 101 to 103, but come to 104 and then we'll go to the orders. And this partly answers your question here. An appeal shall lie from the following orders and save as expressly provided in this code from no other orders. So blank, blank, blank. An order under section 35A, an order under sections 91 or 92, an order under section 5, an order under provisions of the code imposing a fine, arrest or detention, an order made under the rules, Now this last one is important. An order made under rules from which an appeal is expressly provided and allowed by the rules. Now, 105 you can read, which says, no appeal shall lie from an order in exercise of its original appellate jurisdiction, except as otherwise provided. And now you have to come to Order 41. And I'm just showing you this from the index, please. This is Order 41. We'll go through this. Are appeals from original decrees. Order 42 is appeals from appellate decrees. And I want you to come to Order 43 just now, which is appeals from orders, because we went into all of this, but we came to it from the IA interim application stage. Let me just explain this. We will get back to our parent suit in the next few lectures. We will look at framing of issues, taking of evidence, marking of documents, disclosure, resultant decree, and then we will be in Order 41, which is the appeal from the original decree. We are not there yet. We are in the trajectory of a suit, as you're familiar with, still at the IA. Order has been made on the IA. You're drafting a memorandum and appeal being aggrieved by the order dated so and so, not decree. We'll say not judgment and decree. Now this is, I'm dictating this. Being aggrieved by the judgment and order dated so and so. Not being aggrieved by the judgment and decree dated so and so. This is your appeal. By the way, just one heads up, because I will counter this. Please don't assume that no judge reads the grounds of appeal. Some of us have a bad habit of doing this, and it often comes unstuck. Doesn't matter whether you're doing an arbitration appeal or any kind of appeal. Be very careful and cautious about the language that you use when you are assailing the order of a court. Do not use the phrase non-application of mind ever. You reserve this for the writ court when you're dealing with some authority in the municipal corporation or in Mantralaya or some talati or whatever it is. You are happily, you can say non-application of mind, because that may actually be demonstrably probably true and you can probably prove it. You can't say this about judges. You have a judgment. There's no question of non-application of mind. Do not allege bias. If you are alleging bias in an arbitration thing, where it is possible because it's a ground for disqualification, be very, very cautious that you are in a position to establish bias. A mere allegation is not good enough. Do not use the word perverse randomly. I want to explain this. Perversity in law is different from our colloquial, when we use this word perverse, pervert, we're thinking about all the sexual connotations of it. It's not that. Perverse in law means something that is so utterly irrational, that it was impossible for any rational human being to have arrived at that conclusion. That's perversity. Impossible. perversity in law also means that you knew, the judge knew, this is the state of the law. He knew or she knew that the facts had to result in this, but knowing this did the opposite. Knowing this did the opposite. It does happen. It does happen. It does happen in some cases. But if you use the word perverse, don't use it as a word you can chuck around in a memorandum of appeal. You have to use it with caution, because the word perversity then needs to be explained, because why do I say it is perverse? It is for the following reasons. 1, 2, 3, 4, 5. A much better approach, a safer approach, one which is non-controversial and will never land you in trouble, is never to say the judge ignored or the judge overlooked. It's much better to say the learned judge erred in overlooking, that erred in failing to appreciate. It's a little more, but it's kinder and it's gentler, and you will find the value of that when you become a judge and your orders are under challenge. More importantly, it's part of the way we approach law, and if you adopt this approach early on, will stand you in good stead, because law and the practice of law is a discourse, and it is a discourse of civility. Unfortunately, it's become a bit of a bazaar for most courts, but you should not let that lower the standards. So we've got a memorandum of appeal which says appeal from a judgment from an order, and we're in order 43. Now we come to order 43 right away, and we'll come back to the rest. What's the next date? 2 Saturdays from now. Now please read this carefully with me. And then there is one monstrously difficult provision of this letters pattern that we are going to see. Do all of you have a copy of the letters pattern? Or if you don't, can we make sure to get it next time? There are 2 things I want next time. I need the Bombay High Court provisional side rules, and I need the letters pattern with it for the next one. This clause won't be possible unless you have a copy in front of you. All right. Now, order 43, appeals from orders. An appeal shall lie from the following orders under the provisions of section 104. We just saw section 104. Now, an order under rule 10 of order 7, returning a plaint to be presented, an appeal lies. An order under rule 9 of order 9, rejecting an application to set aside the dismissal of a suit. Now, rule 13 of order 9, rejecting an application to set aside a decree. Now just pause for a moment. Decree has been passed ex parte. We'll be doing that next. You have applied to have the decree set aside. You have not filed an appeal, which you could. You sought to set aside that decree, got back to the same court, said it was ex parte, set it aside. And the court dismisses your application and appeal lies from an order. That's what this is about, okay? Then, an order under Rule 21 of Order 40, an order under Rule 34 of Order 21, which is execution, an order under Rule 72 or 92 of 21, an order rejecting an application under Order 21, then you come down to Rule 9 of 22, then you come to Rule 10 of 22, order under Rule 2 of Order 25, order under rules 5 or 7 of order 38 rejecting an application to sue as an indigent person, orders in interpleader suits. Now we're coming on queue, order 38. Now we come to order 39, order 40, and then ultimately the last you forget about 41. So your appeals from interim orders under 39 and 40 come here. Now that answers your question why not all orders are necessarily appealable. Because, now read further on this. Read 1A, which was added by an amendment. Right to challenge non-appealable orders in an appeal against a decree. Look at this in-between grey position that has been put in. A suit went through to a decree, but while it was going through a decree, an order was passed which is not an appealable order. This gives you the right to challenge it when you are challenging the decree. You can challenge that order at that stage. Has to be, because otherwise you are stuck with that order against you without a recourse of an appeal. That's why 1A has been brought to play. Understood? That's the canvas of 1A. Now,
One question.
yeah.
Let's take example of a joinder or agreement of parties. That's not an appealable order under 1.
Correct.
And you include the party. You have a final decree. Then you can only appeal it at the time of first appeal. You can't.
That's correct. At that point. The joinder was wrong. But otherwise you are left without an appeal against that. You are left without an appeal against that. See, actually I have not encountered anybody really challenging orders of joinder ever. Because at the end of the day, an order will be passed or not be passed. How does it matter? How does it matter? And if it doesn't happen, what most people do is where no appeal lies, file a state assembly. That's entirely discretionary. That is not bound by any of these special institutions, are not bound by any of these things. So they'll go there straight away. So it very often happens that from a non-appealable order, there will be an SLP. Now that's the last caveat that I wanted to add. Don't assume that this remains within our playing field of the High Court and our courts. Even if there is a non-appealable order, it will go straight into an SLP in a future date. Okay. Now look, this has been a little heavy today, so let me just tell you where we're going with this. If you go back to the table of contents to the CPC, I want to tell you where we want to go, and I'm going to pick up a speed a little bit. We're now going to get into the issuance of a summons and the appearance and non-appearance of parties on that summons. You have to understand what the concept of a date of summons is. I need the original side rules because there is a slight difference for the Bombay High Court there, which I want to show you, since you will be practicing, and this is not just theory, so you have to know that. After that, we are going to do one peculiar type of suit which has to be injected now because it's a standalone provision, and that's a summary suit. That's a summary suit. That will be a significant portion of your practice, and it is almost, I think, a short question in your CPC papers as well. After that, we'll go back to the regular suits and we'll look at what's happening in the progression of the regular suits up to decree. Okay, so that's the layout frame for next time. Any questions on this so far? Yes.
Section 96.
Sorry, 96.
Yes. We read an appeal shall lie from every decree passed by any court, and we said shall is because.
Yes.
Shall is because it's a matter of right. Whereas in the second appeal, if we
It also says shall lie, but
Also
says,
shall.
but read the next one.
To the High Court from every decree passed in appeal.
That's what I was trying to tell you. If it says shall lie to the High Court from every decree passed in appeal by a court subordinate to the High Court, full stop. Even the second appeal was a matter of right. But it's not. It's made conditional. There's a conditionality attached to this. It shall lie if the High Court is satisfied that the decree, the High Court is not satisfied that it involves a substantial question of law, or the High Court is satisfied that it does not involve a substantial question of law, the second appeal doesn't lie. The word, see, I'll tell you, don't get confused with this word shall in both cases. Just think about it. It was possible to say, and there's a reason why this is not done. Suppose this had said may lie. May lie if the court is satisfied. That changes the complexion, because in a second appeal, then there is discretion even if there is a substantial question. Nothing in this CPC is redundant. Please understand there's a logic to the use of this word. Wait, this is the magic of language. They've used shall for a reason, because once you are satisfied that there is a substantial question of law, it goes in. It goes in. Then you don't have a discretion. If you had said may, that would have created the complication. So this word has been used quite consciously and deliberately there. So there's that distinction. But you have to read the whole thing through. So the conditionality is important, and it is the governing conditionality. Okay, any other questions? Yes.
So, two questions on this very substantial question of law. For it to be a question of law, does it have to necessarily be unsettled?
Okay, very excellent. It's not a question of law. This, what we're talking about here, is not a question of law. It has to be a substantial question of law. So, not every question of law is a substantial question of law. Does it have to be an unsettled, that is, do you have to identify an area where there is no law? No. If you are able to identify that the law as it's stated, is apparently in conflict with other pronouncements, more recent pronouncements, or decisions that do not reconcile or clarify, that is entirely possible. Often in a substantial question of law, you are really, how shall I put it? If any of you are science fiction fans and you are sort of seeing this as a sort of space-time continuum, this is that wormhole through which you are jumping into another universe. This is literally sort of Star Trek, beam me up, Scotty, and light speed. You're going off into some other world, venturing into areas not explored before, going where no man has gone before. That kind of stuff is happening. How are you doing this? You've got to get really, really creative, and you have to really think through what is the law that has been applied. Remember, you're coming in a second appeal from 2 orders below. Now, a second appeal can come in a variety of very peculiar circumstances. A person may have lost in both courts. Original court, first appeal court. The other way is possible. May have lost in the first appellate court. May have won in the first appellate court. May have won in the original court. Lost in the first appellate court and finds himself in the second appellate court. It's entirely possible. Remember, there's this additional complication, which I haven't yet deal with it in decrees. There is a concept of cross objections, not cross appeals. Cross objections. You may have won, but there are portions of this. You may have won, so you can't appeal because you're the successful party. But when the other side appeals, you may have portions that adversely affect you, though you have won, for which you can file what are called cross objections. And first appellate decree can change the complexion of the entire matter quite substantially as a result. So almost anybody could be up in a second appeal. So it's not that you're always looking for uncharted territory there, because there will be hardly any second appeal. But you're looking for areas which are jurisprudentially grey areas, grey zones. You're looking for a final pronouncement. They're very difficult to formulate. It's one of the most, as anyone who has practiced in the districts or has an original practice will tell you, one of the most difficult and challenging things is framing the substantial question of law in a second appeal. It's immensely difficult. Immensely difficult. It requires hours and hours and hours of study, research, to frame it exactly, to frame it precisely. It has to be really, it's really tough. It's really tough. So please get, if you can, soft copies, hard copies. Do we have soft copies of the original sent book? It's on the website?
Yeah.
Just download a soft copy of the original sent book and a copy of the letters pattern for public. So we'll be looking at clause 15. It's a mind-numbing clause. It's really, really, really difficult. It's not of continuing relevance, I think, of diminishing relevance, but you have to know it. It's one of your examiner's top 10 favorites. Clause 12, 15, 17. So we'll be looking at that. Okay, good. Thank you. See you next time.